Good morning and a warm welcome to everyone. Thank you for joining us today. I hope you're all doing well and staying safe. My name is Ifra George and I'm a corporate paralegal at Fichte & Co. and I will be moderating today's webinar session. I just want to state that this webinar will be CLP accredited. As we are aware, artificial intelligence in the UAE and worldwide has been constantly evolving over the years, and with these there have been many legal uncertainties and regulations posed with this development concerning the safety and privacy concerns associated with such. The main question with how UAE policymakers can shape the artificial intelligence landscape within the region. Moreover, we have received a number of questions surrounding the impact of artificial intelligence within the legal sector. Therefore, our webinar today will be focusing on the legality of processing client data via artificial intelligence, the liabilities of the processing firm, the legal aspects of the software used by artificial intelligence, and the future of artificial intelligence in the legal profession. The presentation will be split into two segments, the first half from 11 to 11:30, which will be conducted by our Corporate and Commercial Senior Associate, Dr. Laura Voda, discussing the legal implications surrounding artificial intelligence, including ethics and data regulation, followed by a 30-minute Q&A session. So, without any further delay, let me introduce you to our speaker, and to start off the first segment, Dr. Laura Voda, if I may pass the screen on to you.
Good morning, everybody. Thank you for joining us. Thank you for being here. I think Ifra, we have an older version of the presentation displayed on the screen. There's no agenda showing. However, from my point of view, I'm going to share with you the agenda for today. The agenda for today pertains to how we use artificial intelligence in the legal profession, how we actually deal with it from a legal standpoint, what kind of legal liabilities may appear from the usage of artificial intelligence, how we can segregate these particular, let's say, liabilities, and last but not least, what is the tendency in terms of regulation, because obviously the regulation is a little bit behind the technology, unlike the normal situation in an ideal society where the regulation should take precedence over the technology. In the today's world, it's completely the opposite. So to start with the discussion today, what is artificial intelligence and how it is used for the legal profession? We would say that artificial intelligence is a matter of, let's say, a liberal fashion in the legal profession as of now. It implies enabled machines to, let's say, carry out a lot of tasks that us lawyers generally do, or to issue, let's say, ethical reasonings based on an array of data that they analyze, a process which is largely named deep learning. So deep learning means that a machine-enabled technology is able to actually read certain sequences of data from a multitude of sources and issue, let's say, a determinative judgment based on these. The artificial intelligence in the legal profession is not new. The first experiments have actually carried out 30, 40 years back. And they originate in the American legal market. Probably they've been more innovative than others. And they show that actually on a certain sample of court-appointed experts, the reliability of human-produced data was of 59 to 60%, whereas the machine-produced data had a minimum 20% higher accuracy in determining the outcome of, let's say, legal expertise. For now, a lot of, let's say, technology has been tested. A lot of software is available in the market, from Lex Machina to even, let's say, more complicated softwares. All are well equipped with technology, OCR, optical reading, etc. So they are able to analyze, let's say, a comprehensive amount of data in no time. For the time being, we can assess that the legal profession does use up to a certain extent artificial intelligence. And then the most common form that that this has in the current profession today is automation. Normally, let's say a lawyer that would manually take hours and days to draft a contract can be issued in minutes by filling up a certain template, which is again a software automated result. At the same time, let's say when we discuss about filing intellectual property registrations, or let's say, for instance, patent registrations, the software is actually able to analyze the full features of the patent in no time, in comparison to, let's say, a human that would do that in a comprehensive amount of time. That can be used for the advantage of the beneficiary of the patent, but at the same time that can be used for the beneficiary, for the regulators, because RegTech means exactly that. Yeah. So artificial intelligence can be extremely beneficial. Industry-wise, we use it, for instance, for due diligence. We know that nowadays with the blockchain technology, the middlemen are going to be, let's say, taken out of the picture. Artificial intelligence is part of that, but probably the most sophisticated area where artificial intelligence is used or purported to be used is actually the predictive technology, namely the very exotic, let's say, scenario for now, where the result of a court process or of a determinative process of whatever nature is going to be issued by a robot, by a software, not by us, by humans. This being, let's say, cost effective, time effective, etc. This technology is not yet available, and again, reliance on artificial intelligence is not 100%, let's say, a dogma for the legal profession as of now. There's obviously a lot of variables that need to be considered in that respect, because the artificial intelligence used at the large scale in the legal profession is actually a paradigm shift. The fundamental traditional way of doing the legal profession is by billing hourly a client for the work done by a human. Nowadays, the work, if done by a robot, by let's say by a machine, which is enacted to issue ethical and lawful judgments or appreciations of a legal situation, that would probably shift the full, let's say, legal industry. That would shift the way in which a law firm bills its clients, or shift the way in which, let's say, the clients look into the availability of the legal advice anywhere in the world, or in cross-border transactions, or at the crossroads of multiple jurisdictions or multiple areas of law. Nowadays, for instance, with no particular reference to the legal industry, there are other sectorial usages of artificial intelligence that reflect directly to us lawyers. For instance, we have a lot of automated trading. We have a lot of, let's say, platforms that trade online binary options or any financial products that are of a more sophisticated nature than, let's say, traditional way of trading by humans. On top of that, the artificial intelligence is largely used in the mining industry, for instance, for building autonomous cars, for operating autonomous cars or autonomous ships. In the medical profession, you know that artificial intelligence is highly used in conjunction with the big data for, let's say, determining a number of diseases, the behavior, let's say, traits of humans pertaining to specific diseases, etc. So it's currently used in the treatment of cancer, in the profiling of, let's say, specific classes of population that have a specific, let's say, bias or are prone to developing the disease or already have it. For the sectorial usages of artificial intelligence, obviously, us lawyers are directly, let's say, involved when a legal matter appears. And at that point, the work of a lawyer becomes interdisciplinary, because out of this liberal fashion that, let's say, the artificial intelligence operates in from a technical perspective, from our point of view, as lawyers, there's a certain normativism that needs to surround this usage of artificial intelligence. These codified norms, or this, let's say, general norms that are accepted as binding, as rules, as customary rules or whatever, they do not exist in, let's say, various legislations around the world, despite efforts of the various regulators to issue laws and regulations pertaining to that. However, a body of law dealing exactly with the artificial intelligence and with the proceeds of artificial intelligence doesn't exist per se. Based on our research, and I don't think that we are in any way wrong in assessing that. As said, Ifra, if you wish to please change the slide. We have started our research with the taxman, which was, let's say, the first experiment done in artificial intelligence in legal reasoning by a researcher called Thorne Maharty from the US. The result of this research has been published as early as 1977, so probably we're not saying anything new. The main issue when we discuss legally artificial intelligence is actually the way in which us as humans design a machine to, let's say, reason on our behalf. And then it is, let's say, a basic saying that if you can understand a problem, or if you can sense a problem, if you can reason on a problem, only at that time you can teach as human, or you can program the machine to do it. That was the finding from the very beginning, and indeed these projections of the legal profession need to reflect in the way in which a machine reasons. And then when we look into the structure of the legal systems worldwide, we know that they are not the same. For instance, for a legal system that is extremely predictive, extremely uniform in terms of, let's say, principality, as, for instance, the common law legal systems, probably programming a machine to analyze a set of precedents and issue a determinative ruling, it's easier than in a civil law legal system, for instance, the UAE, where the court and the panel in general retains a higher margin of appreciation, a higher inquisitorial power, and in general parties have a certain limitation in contracting that comes from the codified legislation. Yeah, we know that, for instance, in here, whatever comes in contradiction with, let's say, what is mentioned in the positive law, in the codified law, becomes illegal in a contract and then be quashed away quite easily by the courts, etc. So whenever, let's say, we teach the machine how to learn, or how to, let's say, predict, or how to state behaviors on our behalf, yeah, it is firstly our understanding of things that is being transposed in the machine learning. The problem with the artificial intelligence is that it can become self-sufficient if we, let's say, look into the prophecies of Isaac Asimov and in the relevant literature, which, as we see, are slowly becoming a reality. However, it is noted that the artificial intelligence as of now, yeah, can at some point, let's say, disclose unexpected or surprising facts or surprising truths. And with all the productivity gains that it creates for the legal profession overall, there are instances that prove that technology is not, as of now, fully reliable. And we know, for instance, the case of a bot that has been used a couple of years ago by a large tech company in the United States of America. The bot was programmed to self-learn from the dialogue that it was having with the, let's say, with the auditorium, with the different customers. And then that bot was actually erred in, let's say, making predictive statements on forbidden things. For example, on Hitler, on history matters, which the bot was not even programmed to do in the very beginning. So at this time, this technology is not fully controlled by humans. Yeah, it's a corundum that the humankind still needs to respond to. However, this response should not, let's say, happen in a legal vacuum. And then probably the most important thing when we discuss artificial intelligence is whether the technology is fully reliable and fully, let's say, approachable to humans. And Raiki, if you can show us the next slide. So when we discuss about the ethics and artificial intelligence, we understand that the technology available needs to be accountable, needs to be transparent, needs to be approachable, and needs to be understood. We know that in the world now there's a huge digital divide in between the users and the end user that are able to use the technology at its maximum capacity, and in comparison to the ones that are completely illiterate, I would say, in that particular respect. Obviously, the concept that is used in technology is towards an ethics bounding optimization of the machines. But for the legal profession, that creates a lot of issues, because in optimizing a machine to be ethically bounded, we need to feed data into the software in order to create that final result. And then when it comes to, let's say, to human rights, or to how we generate data or how we feed data into the machine, of this, there's a lot of positive law that can be inserted in the software. And we gave an example, as an example, the European Court of Human Rights and the European Convention of Human Rights adopted under the Council of Europe. However, the machine needs to learn that, let's say, the convention has a certain applicability in time, it has a certain applicability territorially, it has, or it entails a certain, let's say, legal path to be approached when used, etc. I would say that one of the most visible legislative proposals, because it's now in the stage of a resolution, comes from the European Parliament on the civil law rules relating to robotics. And the approach made by the resolution of the European Parliament, so within the European Union, was to create a mandate for the European Commission in order to state what is actually an electronic personality, and up to what extent, let's say, a legal document or a legal effect generated through artificial intelligence or by artificial intelligence is actually legally binding, or has the possibility to produce a legal effect in the same way that acts regulated, issued, or decided by humans can produce this kind of effect. Ifra, if you can please show us the next slide. So the problem that appears for us in the legal profession here is the fact that there's a certain legal risk associated with the usage of artificial intelligence. The question is that, can artificial intelligence do or make a valid, legally binding declaration of intent? Can, for instance, the bots or the software be regarded as having a certain legal personality, either corporate, either individual, etc.? On top of that, this hypothesis cannot be led to, let's say, to the status of being 100% correct, because in artificial intelligence, you have a certain number of stakeholders involved in the development and the operation of the technology. So the data that is fed into an AI system, for instance, by a law firm, it finally depends on a series of pre-existing factors and variables that coexist to the the creation of a certain outcome. So the program, the AI product, for example, Lex Machina, just to give a brief example, yeah, was designed by someone, then has been programmed by someone else. Then the license is distributed by a licensed distributor. Further on, the person from allegedly within a law firm that feeds, yeah, the data into the software is a person that needs to have a specific training, but the person may have a lot of perception biases, such as hindsight, such as, let's say, a lot of gray areas that the operator of the software may not fully understand. And at the same time, the person who is feeding the data into the system is a person that has been trained to feed the data into the system by allegedly a third party. So all the stakeholders that are involved in the creation of AI have a specific, let's say, encumbrance, a specific connection with the outcome. So this process is actually not new, because when we look, for instance, at earlier technologies, the data that is produced through GPS, for example, that's the most, let's say, basic commercial usage of data that is sensed from outer space. So what the satellite is sensing from the lower Earth orbit is not actually the surface of the Earth, it's just an electromagnetic wave that surrounds the surfaces. And then in order to create the image that we use in the GPS, yeah, this image is subject to software processing and cannot be qualified as a primary data. It's a secondary data, and the liability for the accuracy of this data does not belong to a launching state of a satellite, belongs actually mostly to the person who processed this particular data. So by analogy, mutandis mutandis, we can apply the same kind of ratio here. So from a regulatory perspective, obviously we have a situation where we would need to create a lot of, let's say, proposals, yeah, the legiferenda for the legiferation for the legislator in the future. Just to give a couple of examples of what is happening around the world. Now, artificial intelligence is trained to learn on past data, and then the past data takes on past norms that appear in the society. However, these societal norms can change from time to time. For instance, whatever could have been once accepted in a certain part of the world, or in, let's say, in employment matter, yeah, cannot be considered as acceptable in the future. So basically, the artificial intelligence would need to be revalidated, would need to come to a reset point. Now, when we have, let's say, a norm that is codified or a law that is changing, things are quite simple. But whenever it comes to customary norms, or whenever it comes to, let's say, legal issues that are not in black and white in a legal system, that things become interpretable, and the results can be biased even if used by the artificial intelligence. This opens the path to two main categories of data that are actually being used and produced by the usage of these machines, which is open data and proprietary data sets, which again are subject to discussion in our meeting today. Obviously, from a technical perspective, we have a certain, or from a purely ethical perspective, we have a lot of principles that have been developed, for example, in order to embed these ethical components in the artificial intelligence, such as the Asilomar AI principles. However, from a legal perspective, and knowing how the regulation works and how, let's say, the regulation needs to be enacted with, let's say, a specific power by the issuing government, parliament, whatever, or international body, if we are discussing about an international convention issued into an international or intergovernmental organization, and we gave the example of Council of Europe before, we gave the example of the European Union before, the legal risks still appear to be comprehensive, because if we look into various examples of legal systems in the world, none of them associate data produced, or let's say artificial intelligence per se, as being capable to produce a valid declaration of intent. Under the English law, for instance, a robot cannot currently be regarded as an agent, because a person with the mind, so a human, can actually be considered as an agent in the eyes of the law, therefore being capable to produce legally binding output. In US, Germany, the situation is the same. In our research in Germany, we actually found quite an interesting judgment, saying that in the context of a contract formation, according to the case law existing at the Federal Supreme Court, yeah, and as well as according to the prevailing legal literature, machines and software cannot make valid declarations of intent. We looked into the situation of UAE as well, and we studied the civil code, and we have identified minimum 2 articles, 5 and 71, where the result is the same. So the machine cannot produce a valid declaration of intent. Minimally, by referring to Article 5 of the Civil Code of UAE, the provisions relating to the competency or the legal capacity of a subject shall apply to all persons to whom the conditions laid down in such provisions apply. And by persons, or the status of a person or legal personality associated with it, the UAE Civil Code mentions expressly it's the human being that shall commence, and that shall commence at the time of birth, of being born alive, and shall terminate upon his death. So basically, we are not in the position, let's say, to say that under any legal system in the world, a machine, let's say, or a software is actually able to produce a valid declaration of intent. And now moving to the next slide, we can probably assess what can be done. Because if we use a software to actually, let's say, rule on a specific legal matter, we may have a series of liabilities. We can have a product liability that can be, let's say, a form of strict liability tort. And according to the jurisdiction, that can be passed to, let's say, the owner of the software or the developer of the software, as the case may be. We may have, let's say, liabilities in contract that are being produced by, let's say, the usage of this kind of software. Now, for illustration purposes, the European Parliament, in the resolution with the recommendations to the Commission on the civil law rules on robotics, they develop a set of rules which are natural for the usage of artificial intelligence. Aside of, let's say, a charter of robotics, a code of ethical conduct that are for the practitioners who are, let's say, familiar with the public international law, only soft law, and they don't produce binding effects. Specific rules that would be probably developed in the future by the European Commission would be definitely binding. And then, obviously, the problem appears as to what kind of licensing should be issued to the artificial intelligence and who actually has the license to use artificial intelligence. Because if we look into the matter from a purely theoretical perspective, the regulation can entail two main, let's say, directions. Number one, to over-regulate law firms and say that whomever is using artificial intelligence is directly responsible for the result of this artificial intelligence, or to empower artificial intelligence as to the extent where whatever result produced by this artificial intelligence is directly attributable to that particular software or, let's say, machine that has produced the artificial intelligence. And then the discussions that appear in the legal environments now are how to, let's say, generate access to the source codes, how this can be, let's say, put at the disposal of legal experts for certifications, for, let's say, certification of data produced within, let's say, a jurisdictional proceeding, etc. So the questions can be quite comprehensive. And now moving to the next slide, probably the most, let's say, approachable part that that exists now with relation to the artificial intelligence is data regulations. Obviously, data regulations is already a norm. For some parts of the world, we have the GDPR, but then again, there are other legal systems in the world that use the data regulation, one of them being the IFC. We know that they have a new enacted law in 2020 in that respect. So as long as the terminology and the law is actually codified, the binding norm is codified, yes, it can be fed into the system and it can generate, let's say, a quasi-reliable output. However, the problems that appear with the autonomous vehicles, autonomous ships, autonomous machines that do legal work is that they have the ability to produce a large amount of data. We know very well that with a simple click in the internet, we leave behind an immense digital trace. The machines, yeah, and especially artificial intelligence in conjunction with big data have the comprehensive ability to profile individuals, which again contradicts the legislations that appear or are already enacted on the matter, and at the same time can lead to biases, because the person who programs the software can, let's say, transmit specific biases or can induce specific biases in the software in the process of analyzing data. And let's say this may lead to errors, and we gave here a very brief example of what is happening or what can happen in the employment law market, where let's say specific training programs can be wrongly assigned or can be wrongly issued or cannot produce the output that, let's say, a specific employer ought to have at the time of applying them. Conclusively, yeah, and before we open the matter to the Q&A session, if we can move to the next slide, please. At that point, we can assess the fact that insurance on the products can be a solution. However, as of now, we are not aware, and we are not informed of any insurance underwriter or any, let's say, insurer or reinsurer that has a package that is actually applicable to artificial intelligence. So we are using artificial intelligence up to an extent in the legal profession today. We use it for due diligence. We use it for automation of documents. However, the liability for what the machine is producing is finally to the law firm or respectively the lawyer that is actually using it. That's the hypothesis for now. What is going to happen in the future when, let's say, the regulation evolves or it becomes mercurial in the field, would probably have, let's say, a new set of legal personality, different than individual or corporate personality, which can be, let's say, seen as an electronic actually personality, which is going to, let's say, entail legal obligations based on, let's say, acts that are fully automated. And this is going to determine how we are going to use smart contracts in the future, how much legal liabilities this can actually generate, what kind of liabilities that they are being capable to settle, how solvable they are from a legal perspective in that respect. So in terms of regulation, although there are some positive developments, we would say that we are only in the beginning, and there are certain, let's say, steps to be undertaken in that respect. We know that governments in various jurisdictions are already equipped to deal with the problem of artificial intelligence and the legal, let's say, obligations there too. And finally, we know that the federal government in Abu Dhabi already has a department dealing with that specifically. So we are sure that that locally here in UAE, the regulation is on its way. This would be all for today. I hope we didn't take much of your time. I hope that you found our endeavor useful. One more information that we have actually scrutinized while preparing for this webinar is that industry-wise, the artificial intelligence has the biggest prediction of, let's say, growth until 2025. That's by McKinsey Global Institute. And then the second largest industry by 2025 is going to be the cloud structures. So when it comes to cloud structures, obviously they are secured, but in certain jurisdictions, let's say regulators may not allow or actually do not allow certain data to be stored in cloud. For instance, for PSPs, payment processors, etc. Things are quite interesting. It's an industry growth, so I think that the legal profession needs to adapt. But for us, last but not least, it's a paradigm shift, because when the technology will be fully autonomous to be able to support, let's say, a client in his needs without the involvement of a human, then probably the full structure of the legal profession is going to change drastically in comparison to what we have now. Thank you. So let's please open the floor to our speakers, to our guests for questions, if there are any.
Hi, Laura. Yes, thank you for the presentation. We do have a couple of questions that we've received. So the first one says, where is stored the client data during an automation process? Is there any risk of external infiltration to the artificial intelligence program used, or are these 100% protected and safe? Are they usually exempt of liability clauses linked to the use of the software program?
It's a very good question. Quite technical, I would say. The storage of the data can be on a server or can be on a cloud. This depends on how each and every software is programmed to work. Normally, when you feed data into a software for artificial intelligence, this is done according to certain pre-approved templates that the software is actually using in order to insert the data in specific ledgers and categories that makes the software read them. Now, irrespective if the data is stored on a server or on a cloud structure, obviously a risk cannot be 100% alleviated, and one may not assess that, let's say, one storage space is safer than the other. Problems can appear everywhere, data loss can appear everywhere, data breaches can appear everywhere. So I would think actually that to say that data in a specific place is 100% secure, obviously it would be quite surrealistic to say, knowing that let's say the biggest tech companies in the world did have problems with data storage, with data leaks, data breaches, irrespective of how secure that technology was. So we cannot assume that by using artificial intelligence, the data is going to be 100% secure. So it can be stored in a variety of environments, but then finally, each and every software programmer, developer, user has a contributory role on the output generated by the data, and of course in the way in which the software actually works and generates the response to the respective query. So I hope that I have responded to the question.
Yes. So we've just received another question that says, how do we stay in control of a complex intelligence system?
The discussion can be actually extremely complex. We said already in this discussion that the way in which we understand the legal problem is actually how we program the system to think about the problem. Now, this is the basic hypothesis of this discussion. The comprehensive hypothesis appears at the time that the machine is programmed to become autonomous, in the sense that, in very simple words, to learn and self-develop based on the human behaviors. So at that time, when the machine is fully autonomous and, let's say, self-predictive, that's when the discussion can become comprehensive, because if, for instance, there are certain brackets that are being provided in the law up to what is acceptable or what is not acceptable behavioral-wise, normative-wise, customary-wise on the part of a machine, probably things are being set, because that's what we have now for humans. We have positive, negative obligations. But for the machines, these things do not exist. So basically, the results I've seen, although the machines are generally programmed to ethically develop or self-develop, the outcome of, let's say, or the result of a software processed information is not always predictable and is not always controllable. So in the end, there's, I would say, a lot of room for discussion for this particular topic. But then conclusively, I would say that the problem appears when the machines appear fully autonomous, because at that time, if you don't have a strong legislation for backup, then the results can be compromised, can be biased, can be actually surprisingly unreliable or reliable, as the case may be. However, a certain level of expertise on the data needs to be well set in place in order to avoid unwanted consequences of that.
Thank you, Dr. Laura, for the answer. So we've just received a third question, which says, what does the legal scenery in the UAE look like right now regarding artificial intelligence?
UAE, according to the latest statistics, is the fifth country in the world in terms of internet penetration. For everyone who is here, everyone is well aware that artificial intelligence is actually used up to an extent by banks, by, let's say, specific services providers. I would say that we are in, let's say, a prolific area that welcomes such developments. Now, in the legal profession per se, we deem the approach of the UAE as soft and prudential, because of the paradigm shifts that this may imply into the regulation, into, let's say, the exercise of the profession in here. There are specific governmental bodies that look into that. As said, they are specifically authorized in that respect, and we gave this example in the presentation earlier. At the same time, in Dubai, for instance, there's a full initiative dedicated to artificial intelligence. This is Smart Dubai. I think everyone is aware of that. However, in the legal areas per se, as said, the approach is softer, is more prudential, and the legality surrounding these initiatives, Smart Dubai, or let's say usage of bots, as you can see, they are used, for example, to provide information, to, let's say, reliably give indications to a customer, etc. So not to the extent that the bot would actually be able to predict or to issue a determinative judgment on a legal point or a legal matter entrusted to them. So I hope that everyone sees the difference in between these approaches. So yeah, that would be the answer. I hope it responds to our participants' question.
Thank you, Dr. Laura. So we've actually got quite a good question that came in, which says, will insurance protect us from mistakes in artificial intelligence programming?
Yeah, indeed, it's a very good question. As said, we didn't find an underwriter who actually has this type of product on their agenda or provides to the market this kind of product, but definitely they will be in the future. Insurance does protect the user according to the level of regulation that we have now, for as long as the software, the machine is considered a product, for example, a product liability. This can be covered under insurance. But then when we move into, let's say, more comprehensive areas, for instance, we have an arbitration case, and instead of having a panel of arbitrators, we have a software which is fed with data, and the software in minutes predicts or issues a determinative award on a given matter. At that point, if the award is wrong, obviously we have the option to nullify it in the execution fora, which is the court. But we are not sure what can happen at that point with the software that generated it. So for as long as in the regulation the software is actually empowered to have legal liabilities or to generate legal liabilities and is responsible in any way, then at that point we can say that yes, we can probably have let's say a professional indemnity insurance for AI software or for AI machines. So it is possible to have an insurance part. It is also possible to, I don't know, depending on the level of transaction or depending on the type of transaction, to have, let's say, specific auxiliary agreements or legal processes to support the outcome and to minimize an eventual negative effect of AI. In this respect, I don't know, a small example that comes into my mind. For instance, we have a cross-border M&A where, let's say, the jurisdiction clause is at issue, probably it's set to courts, is not enforceable in all jurisdictions involved. And then in order to minimize the claims, you have, let's say, an escrow agreement in place stating that, let's say, the purchase price of the transaction is being paid in a specific period of time and subject to certain conditions. Yeah, that may alleviate the possibility to enter into claims. When it comes to the usage of artificial intelligence, probably we can use this kind of buffers in order to minimize, let's say, an allegedly wrong outcome of the data generated by artificial intelligence. However, this will not be the case in all cases, in all situations. And it's not, let's say, a situation that generates legal protection 100%. But then again, in any transaction, commercial, corporate, whatever, in our days, nowadays, again, a legal protection 100% doesn't exist per se. So if we depart from the hypothesis that artificial intelligence generates 100% reliable outcomes, then that might be too idealistic and would never be, let's say, attainable as such in the real life. But all in all, yeah, insurance is a legal buffer that can support in a variety of ways in order to minimize the unwanted, allegedly negative effects of usage of this software, yes.
Thank you, Dr. Laura, for providing that information. So we have another question that's come in, which says, before giving machines a sense of morality, should humans first define morality in a way that computers can process?
Yeah, it's quite a good question. Thank you for that. We would need to define very clearly what is an ethical norm and what is, let's say, a legal norm, because you see that in any jurisdiction, part of ethics is already codified in the legislation. For instance, even let's say in the legal systems that are newer and in course of development, a lot of ethics are already embedded in the legislation. And a good example here is the UAE. UAE, in comparison with other jurisdictions, is relatively new in developing, let's say, commercially equipped legislation, or in developing, let's say, secular legislation per se. And this is because of the traditional outgrowth of the society. And this is, let's say, a data that cannot be changed. But then, aside from the codified legislation, which is again an instrument and is easily embeddable in the software. It can be easily digitalized. The problem is, how does the ethical part of the robot dealt with? Technically, of course, there are certain principles that are being applied in that respect, but those principles sometimes do not have, let's say, a legal backing in order to be, let's say, considered as binding. So ideally, yeah, we should define morality, and not only define it, to make it in a form that is quantifiable for a software, for a robot. But that thing has not happened so far. So in order to do so, you probably need to go back to the basics and teach the machine whatever, let's say, a human being acquires in a span of a lifetime, probably, or what the collective consciousness of a society has acquired for centuries, probably. So ideally, the process is so, but in the end, how much of these nuances, of these tones that we have in our day-to-day life, we can embed in an algorithm, that's incredibly difficult to assess at this stage, and I think even in the future. So in order for, let's say, for the algorithm to read data, I think that's an easy thing to do. What kind of data we program the algorithm to read, that is the major problem, I would say. And for as long as this data cannot be quantified in exact terms, it would be equally difficult to issue, let's say, a statement on what kind of liabilities the machine has for the data that it has processed. So that's how I see this problem from let's say, a legal and ethical perspective. So I hope that I responded to our participants' question.
Thank you, Dr. Laura, for the response. So we have another question that has come in, which says, will an accident caused by artificial intelligence make me responsible to third parties?
In order to respond to this question, I would say, well, yeah, it depends who's asking, because as said, artificial intelligence now, I mean, there's something that we are already familiar with. So we use artificial intelligence. So we have autonomous driverless vehicles. We use artificial intelligence in a variety of ways, and even us in the legal profession, we use it subject to the, let's say, regulation that we have available with us now. Now, when you look into what the artificial intelligence comprises, such as data collection, optical recognition, the OCR, emotional recognition, automation, autonomous computing, predictable APIs. So you see, we already have a lot of variables in the discussion. So if the person who is using the artificial intelligence is, by hypothesis, a lawyer that, let's say, relies on the result of this artificial intelligence in a due diligence process, then definitely in the status of regulation that we have now, that lawyer is going to be accountable for what he said to the client based on the findings of this artificial intelligence. And then if this artificial intelligence is a software, comparing to, let's say, to the data that we have available today, yeah, at today's talking, at today's time, then probably that particular user, the lawyer by hypothesis, would be able to go and claim liability from, let's say, from the software developer for an alleged error. And then it's going to be subject to a technical expertise to see from where the error is coming, if the source code has a problem, etc. So that's how things would go now. In the future, if, for instance, the regulation changes and actually the usage of artificial intelligence becomes the new fashion, I would say, in the legal profession, then obviously things may change. And the person using artificial intelligence would be probably liable only to what kind of data he or she feeds to the machine. The machine being, let's say, allegedly self-learning, would probably generate an outcome that would make the machine directly liable. So that's a tendency that we foresee. However, it's not there yet in the legislation, and we are unsure when this is going to happen. The developments around the world are, as we've seen, quite heterogeneous, and there's no uniform, let's say, status of regulation on any aspect related to the artificial intelligence. What is uniform is actually the development of technology, which is something else. It's something of a very evolutionary nature everywhere in the world. So I think we all know that. But then again, this is, I would say, outside the topic that we have for today. So I hope that I have responded to our participants' questions with this.
Thank you, Dr. Laura. So as we're just running out of time, I'll just ask one quick question before we close today's session. And that question is, if you're a business, you can't probably assume all risks related to your product, especially the unpredictable ones. How do you then draw up a fair contract between your clients, yourself, and ultimately the users?
Well, and where does the artificial intelligence come exactly into the picture in this question? Because obviously, if let's say a business provider relies on artificial intelligence, that we would need to go back to the early discussion where we said that as per the current status of regulation that we have worldwide, I would say, you would not be able to make, let's say, or you don't have an electronic personality, you have a legal personality of a human that uses the AI either as a corporate entity, either as an individual. So the liability lies with the user, and or if the outcome is produced towards a third party. And then for the product, we can go back and claim, let's say, product liability from the developer, from the software engineer, etc. So to respond to this question in particular, I would say that drafting a proper contract is a simple thing to do. This is something that we know how to do, and we've been doing as humans for an enormous number of years. Now, if the participant who actually asked this question looks into let's say a smart contract, for instance, then these are not highly used as of now. There are many reservations in relation to that due to the lack of or debatable enforcement of the obligations that arise there too in many areas. So my own advice in that particular sense is that, yeah, ethical contracts can be always drafted, but then to give a specific answer to the client, I would need to understand, to the participant, I would need to understand exactly which are the internal, let's say, ingredients that he has or she has in mind whilst making this or addressing this question to us. So that's what I would respond to this.
Thank you, Dr. Laura, for answering those questions. So we have arrived at the end of today's session. As informed in the beginning of the webinar that due to time constraints, we might not be able to answer all the queries. However, we will be conducting future webinars on similar topics to answer all of your questions. With that being said, you may also send your questions to our info mail, that is at info@fichtelegal.com. On that note, I would like to thank everyone who has joined our webinar session today. And also for your information, the presentation slides and the full recording of today's session will be published on our website later today. So do keep an eye on our LinkedIn and Twitter pages for the update. And thank you, Dr. Laura, once again for presenting and answering the queries. So goodbye, everyone. And until next time, this concludes today's session.